If you're watching this video, you're probably trying to figure out how to actually get divorced in Australia. The process isn't as complicated as most people think, but there are specific requirements you need to meet. In my 17 years as a family lawyer here in Sydney, I've helped hundreds of people through this exact process. Most come to me thinking they need to prove their spouse did something wrong, or that divorce automatically means losing their house or kids. That's not how it works in Australia. I'm John Boy, Principal Solicitor at JB Solicitors. I handle complex family law cases, including international divorces, and I'm a nationally accredited family law mediator and arbitrator. And today, I'm going to walk you through the 6 steps to file for divorce in Australia. First, let me clarify what divorce actually does. Divorce legally ends your marriage so you can remarry if you want to. It doesn't divide your property, it doesn't determine custody, and it doesn't set up child support. Those are separate legal processes, and this video is specifically focusing on the steps to filing for a divorce. So let's get straight into the first one, which is checking if you are eligible. To file for divorce in Australia, you must meet 2 basic requirements. First, separation. You've been separated for at least 12 months and 1 day. And second, connection to Australia. Either you or your spouse must be an Australian citizen, hold permanent residency, or have lived in Australia for at least 12 months before filing. There used to be a third requirement, which had to do with marriage length. Basically, if you had been married for less than 2 years, you'd have to attend marriage counselling or apply for an exemption. However, since June 2025, this is no longer a requirement. So you can proceed to step 2 if you meet the 2 basic requirements in step 1. Step 2 involves proving that you're separated, but you still have to prove 3 things to the court. First, intention. 1 or both of you decided to end the relationship. That's enough. You don't need mutual agreement. 2, communication. You told your spouse clearly. This could be a conversation, a text, even an email. Something as simple as, we're done. Simple language, but it needs to be said. Third, action. You acted on the decision. Examples include sleeping in separate bedrooms, opening up your own bank account, cooking separately, letting family or friends know, or not attending social events as a couple. If you are still living together, the court will ask for a written statement called an affidavit explaining how you've been living apart. If you've met the eligibility criteria, you can proceed to step 3, which involves getting your documents ready. You'll need these things before you apply. Your marriage certificate, translated if not in English, proof of Australian citizenship or residency, affidavits if you are separated but living under one roof, and if applicable, details about children under 18, including who they live with, schooling, healthcare, and financial support. The court will not grant the divorce unless it's satisfied that proper arrangements have been made for their care. This doesn't mean you need formal parenting orders or court-approved agreements. Informal arrangements are acceptable as long as they are clear, consistent, and in the child's best interest. For example, you'll need to show who the children will live with on a day-to-day basis. This could be full-time with one parent or a shared care arrangement. If they move between homes, outline the schedule. The court won't interrogate every detail, but it does need to be confident that the children's welfare has been thought through, that there's stability, communication, and a functional co-parenting setup, even if informal. If no agreement exists yet, or if you've just started mediation, make sure to mention that it's better to show you are addressing it than to leave it vague or blank, which can delay the divorce. Once you've confirmed your eligibility and gathered the necessary documents, you're ready to file your divorce application, which is step 4. This is done online through the Commonwealth Court portals. That's the official government website where all family law applications are lodged. To begin, you'll need to create an account if you don't already have one. From there, you can start a new divorce application and follow the step-by-step prompts. You have 2 options when it comes to how you apply a joint application or a sole application. A joint application means both you and your spouse apply together. This is the simplest path. if you are on reasonably good terms and can agree on the contents of the application. You'll both need to sign the application. There is no need to serve documents on the other party because you are filing it together, and neither of you can later dispute the divorce or challenge the facts in the application. So this option is often faster, cheaper, and less stressful, especially if there are no children involved. A sole application means one of you applies without the other's involvement. This is common where communication has broken down or when one party doesn't want to participate. If you go through this route, you'll need to serve the application on your spouse. This means formally delivering the documents so they are aware of the divorce proceedings. Service can be done by hand, by post, or by a professional process server, but you cannot serve them yourself. If it is sent via post, the spouse is required to send a signed acknowledgement of service back to them. After service is completed, you must file an affidavit of service, which is a sworn document providing to the court that your spouse received the application and was given a chance to respond. If your spouse cannot be located, you can apply to the court for substitute service. This means serving via email or family member or dispensation of service depending on the situation. A dispensation of service is a legal request you make to the court asking for permission not to serve divorce papers on your spouse at all. Keep in mind that if you are filing a sole application and you have children under 18, you'll likely need to attend a short court hearing, either in person or online. More on that in step 5. There is a filing fee payable at the time you submit your application. As of now, it's around $1,000. But if you hold certain government concessional cards or you are experiencing financial hardship, you may be eligible for a fee reduction. The portal will guide you through this eligibility checklist as you apply. Once you've followed all the steps, make sure to double check every section before submitting. Even small mistakes like an incomplete date, a missing attachment, or a mismatch in names can cause delays and require refiling. Once you've filed your divorce application, the court will review it and schedule a hearing date, which is step 5. But whether or not you need to attend the hearing depends on 2 main things: whether you applied jointly or alone, whether you and your spouse have any children under 18. If you or your spouse filed a joint application and you don't have children under 18 from the marriage, the process is usually straightforward. In this case, the court will set a hearing date, but you are not required to attend. If everything is in order, the divorce will be granted at the hearing in your absence. If you filed a sole application but there are no children under 18, attendance is also generally not required. The court will assess application on paper, and as long as the other party was properly served, no objections were raised, and the documents are complete and accurate, then the court will usually finalize the divorce at the hearing without you needing to attend. There are exceptions though. For example, if there are errors in your application, or if your spouse has filed a response challenging the facts. But in a standard, uncontested divorce with no children is typically handed without appearance. If you or your spouse have children under 18 from the marriage, then in this case, especially in sole applications, the applicant must attend the hearing. This hearing is often conducted virtually using Microsoft Teams and typically lasts around 15 to 30 minutes. The court wants to confirm that appropriate arrangements are in place for the children's care and welfare, that the application includes complete and accurate information about the children, and that there's nothing concerning or unclear in your answers about their living, schooling, healthcare, and financial support. You won't need to argue your case or be cross-examined. It's like a trial, but you do need to be available to answer any basic questions the registrar or judicial officer may have. If your paperwork is clear and the court is satisfied with the arrangements, the divorce will be granted at the end of the hearing. Once the hearing is complete and the court approves your application, your divorce will be finalized 1 month and 1 day later. So, step 6 is to wait to get your divorce certificate. You're not officially divorced until then, so you can't get married until the order is issued. Attempting to do so earlier is considered bigamy, which is a criminal offense in Australia. Before I wrap up, I thought I'd just run through really common questions I get asked in the divorce process. And that is, what if I live overseas? And will a divorce affect my visa? If you're overseas, you can still apply for a divorce in Australia, as long as either you or your spouse meets one of the legal connection requirements, which is that you must either be an Australian citizen or permanent resident. You or your spouse must have lived in Australia for at least 12 months immediately before filing the divorce. In terms of the visa question, divorce can affect your visa, depending on what type of visa it is. If you're in Australia on a partner visa, temporary or provisional, your visa may be linked to the continuation of your relationship. So filing for divorce could impact your visa status. The family court does not assess immigration matters, but once a divorce is filed or granted, the Department of Home Affairs may assess your visa eligibility. If you are on a partner visa or your spouse is your sponsor, it's strongly recommended that you speak to a registered migration agent or immigration lawyer at the same time as seeking advice from a family lawyer. So that wraps up the divorce process in Australia. Of course, this covered very basic scenarios, but in some cases, the actual divorce application is relatively simple and you can file it yourself. But if you have kids under 18, or if your situation is more complex, it's best to get legal help. Check the link in the description if you'd like to speak with a lawyer one-on-one. Otherwise, I'll see you in the next video. Cheers.